the battle line that's emerging, and it's actually emerged earlier than usual, so I'm going to give you some of the context. The trial's timing and the evidence in this trial are now going to be litigated and fought over more than usual, and I'm going to explain to you exactly why. We just talked a little bit about why this is the big one. It's different than the New York case. Indeed, if Georgia acts, and we don't know what they'll do, it is in some ways the bigger problem for Donald Trump than a Georgia case. So we've already been seeing a line of attack. This is before today's arraignment. You're going to see it come up twice. First out of court, then in court. It's a line of attack that we first heard from Trump lawyer John Lauro, and he previewed this before the arraignment.
He had 3.5 years. Why don't we make it equal? Okay. The bottom line is that they have 60 federal agents working on this, 60 lawyers, all kinds of government personnel, and we get this indictment and they want to go to trial in 90 days. Does that sound like justice to you?
Does that sound like justice? Now, that's the Trump lawyer there attacking the timing, because the DOJ did, and this is just a factual piece of history, the DOJ did take a pretty long time to bring this case. Everybody knows it basically originated and focused on January 2021. But think about this. If he is complaining that it took so long, years, why would you want to make it take even longer now? Well, that's actually what we learned about today, earlier than usual in the arraignment. Now, what I just showed you there is obviously public. He's doing interviews. But late today in the arraignment, we saw the strategy is to push for a kind of fight over evidence as a mechanism, call it a tool or even a ploy, to drag out when this trial begins. Now, that matters. It's also telling. Mr. Lauro basically hit this point in court today. He referred to Jack Smith. What I'm about to read to you is him referring to Jack Smith under the formal court term, which is the government, because Smith represents the government. That's why it's the U.S. versus defendant Trump. And here's what he said, quote, "For the government to suggest that this case can be tried in the same period of the Speedy Trial Act is somewhat absurd." Lauro goes on to say what we need from the government is an understanding of the magnitude of discovery of all of the evidence they have. And the prosecution goes on to argue, quote, "This case," that's the prosecutor who works for Smith, saying this case will benefit from normal order, including a speedy trial. And you see that clash. Let's be very clear, because I don't think everyone sits around reading arraignment transcripts. You don't even usually debate evidence and discovery at an arraignment. You certainly don't get into the Speedy Trial Act and all this other stuff. And we were discussing this a little bit earlier during the breaking news coverage, and Rachel and I were talking about the fact that, yes, they are entitled to look at all the evidence and get time for that. But something else is going on here. I'm giving you my preview of what I think that is, which includes a real fear about this case more than the other ones, and an immediate effort to cede the ground, to get the public information out there. They want to publicly argue on behalf of Trump on TV and in court that somehow this is being rushed, it's not fair, they need more time. Heck, they might need till 2025. Now, our experts are still here, and we're going to bring in SDNY chief and my former boss, David Kelly. Welcome back, sir.
No, nice to be with you.
David, I want to go to you first. We're going to go yes or no. Do you typically resolve evidence and discovery questions at an arraignment?
I thought you were going to give me the pop question on whether or not Andrew's a nerd, but I'll go with that question.
I mean, you can weigh in on that. We know Andrew. Do you want to weigh in on that?
Too
easy.
I've
That's
known
too
Andrew
easy.
for decades, and I'm a big fan of his. But anyway, no, that's not something that typically comes up in the course of an arraignment. And look, part of the defense here is not what you can do in the courtroom, because a lot of what they're talking about can't be done in a courtroom.
Right. So let me redirect you. So, because again, sometimes we go so fast, it's like, first, this is not what you normally do with your arraignment time. So that's on its face abnormal, and we can remind viewers who are following this arraignment today, the magistrate didn't say, "You're right, we're gonna wait a long time." No, they just did what you normally do, which is just set the very next date, which is the first appearance before the actual judge. So now I go to the longer.
It's typically the first appearance before the judge to whom the case is assigned.
Exactly. So now I go to the longer question for you, given that you've prosecuted terrorists, corrupt defendants, etc. What do you actually think is happening here? Because this was a longer arraignment because of that move. Mr. Lauro is making this case. Jack Smith clearly wants a fast trial. He said so. So what's going on here, David?
What's going on is that they're planting the seed their defense is to try this in the public arena, because a lot of what they want as a defense is not going to be admissible or not going to work in a courtroom. And so part of that is, again, the whole Trump mantra, I'm a victim. I can't possibly take this case to trial in the time that the government wants to. It would be incredibly unfair. And there's too much discovery. There's too much going on. Can't do it. It's not such a big deal that they raised it at the arraignment. It is unusual because the magistrate judge is there to read him his rights, read him, apprise him of his charges, assure he has counsel, and say, okay, here's the date you go see the judge who's going to try the case.
So as a prosecutor, again, given your extensive experience, how would you expect Jack Smith's team to counter this if this maintains its spot as the first big clash?
I think if I was Jack Smith, I wouldn't really get distracted by what he's trying to do outside the courtroom, because I think he should just really focus on what he can and will do within the courtroom. I think that's probably going to be Jack Smith's approach to this. I think it's the right approach, because you can say all this stuff that you want now, but when he gets in front of a jury, and I think particularly one from the D.C. jury pool, this stuff ain't going to fly.
Basically, you sound really confident. You know what they're doing. You don't think it's that debatable. I mean, they're going to say a version of what we just heard, in fairness to the judge, and say, hey, the DOJ had all this time. They spent all this time. It's 2.5 years later. Now they come around to us. Now they tell us they have no time, and we need till after the election. Then what happens?
Yeah, so look, they can make that argument. I think it doesn't really hold a lot of water. What does hold more water, and the one thing I will agree with Lauro, albeit he brought up at a time that I think was inappropriate, is to start talking about discovery and to have an understanding of how much discovery they're going to have to go through. I think the other bigger challenge is not just discovery, but this particular defendant's own court schedule. He's got lots of commitments.
You put that very, David. You put that very diplomatically.
So, look, he's got all these cases. He's got to be tried for it. And look, in response to what Lauro said, the government can investigate something for 10, 20 years, but the Speedy Trial Clock, Speedy Trial Act says you have 70 days. Obviously, there's a lot of exclusions there. I think you make a good point. Why would they want it to drag on even more? I think also, look, 2.5 years since the incident and just getting to indictment now, I don't think that's such a big deal. What is important and what the judge has to focus on, tell me, government, how much discovery is there to go through, number one. Number two, defense, tell me what litigation you're going to engage in before we go forward. What pretrial motions are you anticipating? And then the judge can assess, well, look, that's a no-brainer. It'll take me 5 minutes to decide that one. This one may decide, take a little bit more time, a little bit more briefing, maybe an oral argument, but it will help the judge fashion a smart schedule that is unassailable, that he cannot legitimately claim, at least from a legal standard, is one that's inappropriate.
So I think it was a pretty typical arraignment. There obviously was a little bit more detail, and I think the defense, as some of your previous people have said, is clearly laying the groundwork for a strategy to delay the case as long as possible. And they started planting the seeds for that today. But other than that, and other than just this very spectacle of having a former president appear in a federal court and be arraigned on criminal charges, which is itself extraordinary, it was a fairly routine proceeding.
Copy. Turning to the unindicted co-conspirators that are named by the Justice Department, you certainly have dealt with cases that are about one defendant or what we sometimes call violent or physical crimes, where you say this was the interaction and the case proceeds there. Were they there? Do you have fingerprints? Do you have a weapon? And that's the normal course. People know that, I think, from Law and Order shows. There are many cases, though, that can be quite complicated with other figures. And here, 5 of the 6 identified unindicted co-conspirators are lawyers. One was actually serving in the Justice Department at the time. That is a significant thing when you look at the fact that one of the early public defenses offered by Donald Trump's criminal defense lawyers is that he was advising, he was taking the advising and advice he got from counsel, and that's why he did everything he did. For your reaction, I want to play something pretty recent from Trump's lawyer. Take a look.
Everything that Mr. Trump requested to be done was done with the advice of counsel, was done with lawyers giving him advice.
He also had many opinions of his own White House counsel that was not legal.
No, you're entitled to believe and trust advice of counsel. This is an attack on free speech and political advocacy.
Given your experience, we don't know everything about this case yet. We have the indictment. But in your experience, have you seen that defense work for defendants? How does the DOJ, in your experience, deal with it? And does it weaken that defense if several of your alleged co-conspirators are lawyers?
So I've certainly seen that defense raised many, many times, and it can be effective. But one of the components of the defense is that you have to actually be relying in good faith on the advice of counsel. If you're shopping for lawyers who will tell you what you want to hear, that's not the same as relying on the honest advice of a lawyer who's giving you real legal advice.